So sorry for the false start. I wanted to make one final record on the court's ruling. I respect the court's ruling on the
Go ahead, you can make your record.
Maybe it would be better if I did it over here. I wanted to interpose an objection to...
So I think it would be better if you did it over here.
It's illegal. It's just a legal one.
I don't know what you're doing. Come over here and tell me what you're going to do, and then I'll be back there and do it.
May I get that?
Yes.
Okay. As it relates to the 4 exhibits that the court deemed were not admissible because of a violation of Rule 14, I wanted to elaborate just very briefly.
Go ahead.
Our objection. We believe that under Rule 14, we were not obligated to have to present these exhibits to the Commonwealth in discovery. Rule 14 does not require such disclosure when the exhibits are used for impeachment only. And that's exactly what those 4 exhibits were going to be used for and what we intended to use them for. Had this witness said, I know Caitlin Albert, we've been friends for 10 years, we went to high school together, we've been on day trips together, we've been to the beach together, and we've socialized together. I wouldn't have to show any photographs, but that's not what she said. What she said was, I went to high school with a person named Caitlin Albert, which is a bastardization of the truth. That's not the truth. And those 4 photographs are what got her, in the voir dire process, what got her to admit that she, in fact, does know Caitlin Albert, and those are on a very, very different level than she first suggested. As the SJC is explained in the case of Commonwealth versus Aguiar, Aguiar, at 400 Mass 508, pin site at 513. It's a 1987 case that says the following, and then I'll finish my record. Quote, a defendant has a constitutional right to bring to a jury's attention any circumstance which may materially affect the testimony of an adverse witness, which might lead the jury to find that the witness is under an influence to prevaricate. It matters not that the evidence would reveal an otherwise inadmissible fact, such as the witness's commission of a crime. A judge may not restrict cross-examination of a material witness by foreclosing inquiry into a subject that could show bias or prejudice on the part of the witness, end quote. And that's exactly what we believe we were entitled to do with Katie McLaughlin as a witness for the Commonwealth. She has bias, or at least the jurors can consider a bias. She has prejudice. The jurors could consider a prejudice because of a pre-existing relationship with Caitlin Albert about which she was not truthful. So I wanted to make that record and ask the court to reconsider whether or not those 4 exhibits could be introduced. I don't need to make any big deal about it. I don't want to call her back to the stand, but I think the jurors, now having had the description of those photographs, should be able to see them in evidence. And I would submit.
All right, so that request is denied. The record's clear. So Ms. Reed is not going on this view. She just needs to make sure she's back here by the time we return. So Mr. Yannetti, you're nodding.
Yes,
you will contact her and make sure she's back here.
Understood.
All right, to the court, please.